morning, everybody. Welcome to Law and Crime. I'm Jesse Weber, joined here by criminal defense attorney Phillip Hamilton. We got a lot to cover here on the network, where we cover the most interesting live trials and legal stories in the news today. So let's get started. All right, Phillip, as we're watching that, you made the point, it seems the prosecutor's even unsure who did this, but the idea that David Dooley might have been engaged in some suspicious comments and behavior after Michelle Mockbee died, what do you make of that?
That's the prosecution's job, right? The defense's job in any of these matters when you're dealing, and let's be frank, everything that we're discussing right now is circumstantial, right? The fact that he left a different way than he normally comes in, the fact that he went home for whatever reason, his wife's sick, whatever he had to go home, his pants are unzipped, whatever. The fact of the matter is the prosecution has to put these together as building blocks, right? It's the defense's job to break this down into isolation and to just make it clear that the fact that he went a different way as opposed to normal does not mean that he just committed an assassination, you know, a bludgeoned homicide. It's just the fact that he went that way for whatever reason, but that doesn't prove, you know, the elements that they ultimately have to.
But it's strange, and we're going to talk more about it. We have to take a quick break. When we come back, we may be live in the David Dooley case. We'll be right back. Okay, this is the beginning of the medical examiner's testimony. Phillip, what do you make of it so far?
Right now, they're just, as you noticed with the prosecution asking whether or not the thyroid issue had anything to do with her death, they're just trying to start to narrow down just the point blank basics. How is it that she died? Was it a result of anything else but the assault? And the blunt force trauma. And
also trying to show that, hey, listen, there was nothing improper about the investigation. I did everything based upon protocol, which is important.
Oh, no, absolutely. From just the way that I open the bag and making sure that I take pictures of the body as is. I mean, it's a body, so you don't want to necessarily use the terminology that's generally used with property, but it's akin to a chain of custody issue. You know, just making sure that, you know, there was nothing outside of the line, you know, no contamination on my end, nothing that ultimately would have, you know, skewed this, my findings one way or the other.
Because if you're a defense attorney, it's like a shark going to find it and see if there's anything improper, going to jump on it.
You're going to jump on it.
Exactly. All right, let's take a quick break. When we come back, we'll be live in the court. So as we listen to this, Phillip, you had told me something interesting about, you know, a case that you worked, and this in relation to the weapon being used. And remember, there's no murder weapon found in this case. Yes, a knife was found that may have had blood on it, but no murder weapon is actually being found. What did you explain to me during the break?
In these cases where the pathologist, the forensic pathologist, whomever, are breaking down like blunt force trauma and what exactly that means, particularly when it comes to identifying whether or not a weapon is used, it's not always as cut and dry as the testimony sometimes comes across in terms of being able to identify what it was that caused the blunt force trauma. Because as we're listening to this particular pathologist, he's making clear that as opposed to like a sharp force injury, when you're dealing with blunt force, you're literally dealing with what the term implies. When something hits you very hard, what ultimately happens is that like that shock wave that's kind of going through the skin can be so much that it can crush it and split it open, right? Now, what you and I were kind of talking about was, you know, there are situations where if you think about a boxing match, right? There are times when someone's eye might get split open from a punch. And in that respect, generally a boxer is going to be wearing gloves, right? So even to the extent that you're wearing gloves, if the force is hard enough, it can split the skin open. Now, this is a case where, again, they didn't find the murder weapon. They're alleging it to be a tape gun, which is very specific, you know, in terms of a suspicion, when at the end of the day, we're just kind of dealing with like a lot of amorphous blunt force lacerations, right? And, you know, in the case that I was kind of talking with you about, we had a situation where, you know, was a weapon used at all? And, you know, they were trying to make that point, and that's a bit hard because it's not always cut and dry.
Yeah, no, and especially in this case where we're still trying to figure out exactly what happened. We know that she was brutally killed and left to die. That is a fact. Let's take a quick break and we'll be right back. Okay, Phillip, aside from how tragic this whole set of circumstances is, this killing appeared to have happened quickly, didn't it? And does the time frame make sense to you about how quickly this must have happened?
I mean, like the pathologist is saying, she didn't die quickly, but in terms of just the events that ultimately led to her death, you know, they did. Does it make sense? Yeah, you see this in the course of practice. Like, you've seen situations where, you know, to the extent And this kind of, I think, plays against the defense, but to the extent that it had to happen quickly because he had to go and circumstantially make these runs or like to get there before anybody else got to work and get out, you know, it's a little bit damning, but, you know, to the extent that it proves the entire case, no, but it's a building block. Let's just say that.
It's similar to the other case we're covering, the Hallbrook. Again, a crime had to have happened in 30 minutes and take care of everything, clean everything, and it raises some questions. And we're going to talk more about those questions right after our next break. Stay tuned here on Law and Crime. Philip, you made a good point to me that the defense has been kind of quiet. I mean, they're not objecting. What do you make of that?
What I make of that is that their theory is solid, that our client is not the individual who caused this murder. It's unfortunate what happened to her. It's clearly being shown that she was murdered in a horrendous way. We're not opposing that. We're just simply saying that he didn't do this. So again, for the prosecution, they have to build their case that ultimately she was murdered and everything along those lines. We respect that. We'll deal with other we'll deal with other aspects of the case when it gets to showing why it's not our client.
Right. Well, they're not objecting, but maybe we'll see what they ask under cross-examination. That'll be interesting. Let's keep going, and we're going to go live back in the courtroom. So the defense may not be doing any objections, but we talked about cross-examination. Where do you think they might go for this witness?
I think an area I would go with respect to this witness is kind of playing up the nature of those blunt force injuries, right? In terms of how much blood spatter would one expect to see upon being, you know, hit at the force that her skin was split open, and you know, we had a number of abrasions, a number of cuts, self-defense wounds, all of this and that. You know, the most compelling thing I think for the defense is that not a pinprick of blood was found in Dooley's truck, right? Which was the escape truck that he ultimately left and then came back 20 minutes later.
And his DNA wasn't found at the crime scene.
Things that you would expect to see, things that you would expect to be there. And so that's definitely an area that may be why the defense is just sitting back right now, because, you know, we're going to explore this in depth in cross.
And I get it. He's a janitor. He cleans. He might be able to clean things up, but this well, I don't know about that. Yeah. And we heard last week, you know, the bleach in the sink, that there was a strong odor of that, but that was his job. He's a
contract cleaner.
Right. But again, no murder weapon, no eyewitness to the attack. They find her body. They see him leave. He acts suspicious. There might have been doctoring of time cards. These are the kind of interesting moments that we're following, but how much is the jury going to hold on to?
I mean, that's the defense's job in terms of, you know, making them move away from that and look at the bigger case picture that, again, at the end of the day, no weapon, okay? Don't know who did this, still haven't really proven a huge MO for the level of injuries that we see apparent here. Do they get fired for that? Do they lose their jobs? I don't know. They're going to have to kind of prove those things up.
You know, one of the interesting things was the screwdriver that they found in Dooley's possession that might have been used to pry the lock of Michelle Mockby's office, because it was believed that she had kept that lock. Again, circumstantial evidence, but they're building a story, and the defense seems to be going a different way than they did that first time around, where he was ultimately convicted. They're pointing the finger at an alternative suspect, Dan Mockby, Michelle Mockby's husband, and I want to talk with you about that more a little bit later. Let's just take a quick break, and when we come back, we will be back in Dooley. So if you've been following this case for a while, you'll recall that this witness testified in the first trial and said that it seems consistent that this tape gun could have been the murder weapon, even though no murder weapon was found. But he said if you look at the different ways that it's constructed, it would have created the injuries he just talked about. That's an interesting theory. I'm curious what your thoughts are on that.
It depends on what the nature of my defense theory is, right? If at the end of the day I have a case wherein it's imperative for me to prove that a weapon was not used, okay? Or if there is some other issue by which the nature of the weapon is an important area of my defense in terms of running away from,
right,
well then this is very circumstantial. He's conceding that although the injuries are consistent with the tape gun, I can't say like 100% definitively that it is. So in certain cases, I would jump all over that. Again, in this case, as the defense, where it's just clear for us that it's not our client that committed the murder, you have enough battles to fight. I don't know necessarily if I'm picking this battle in terms of was it a tape gun, was it not?
Because they could say, hey, listen, yeah, someone took that tape gun and killed her. Just wasn't our client.
Yeah, if you find a tape gun with my client's DNA, let's talk then, and then we'll figure out, you know, what we're doing with the
Do you think they're going to say that under cross-examination? Hey, did you find a tape gun with our client's DNA?
Yeah, did you test my client's DNA on a tape gun or any weapon for that matter? You know, just you don't even have to like parse that one out very heavily. That point is ultimately made, and I think a jury, if I'm on the jury or whether I'm the defense attorney arguing it, like I get it either way.
Without a murder weapon, is it sometimes hard to convict?
The jury needs to see it, right? Because to the extent that you have a murder weapon, you might have someone else's DNA on it. You have a whole host of areas by which could be tested that could potentially not be the defendant that's on trial. That as a defense attorney, you're definitely going to play it up. And remember, as the defense, you only need to get one juror. The prosecution has to get 12. They
were able to convince a jury the first time around, the state, to convict him. So something worked.
It did, but then also, like we're saying, the reason that we have a subsequent case now, we have the tape, you know, with the other person that's come in. We have some other MOs that I don't know necessarily if what they were able to use first time works.
Right, and I want to talk about those other theories put forward by the defense. Let's take a quick break, and we'll be right back here on Law and Crime.